Um, Good afternoon, everyone. My name is Franklin Runge. I am the state law librarian for Montana. I am excited to be here today to talk about an update on landlord and tenant law. I won't be talking. I'm just doing a brief introduction, thankfully. Today, we are going to be hearing from Shane Cashin and Wednesday Selassie. A few quick housekeeping matters. There will be time during this presentation for questions and answers. The presenters have sort of reserved two sort of moments in time for that. So during their presentation, they'll let you. For those of you watching online on Zoom, please be aware that we will be sort of watching chat, but our answers to your chat questions will be done during that reserved time. And for those of you that have joined us live in person, if you have questions, please ask away. But once again, we ask that you reserve your time for when the speakers want to sort of manage that question period. We're happy to be able to provide for the bar this CLE credit program. The CLE credit is pending, and the application has been submitted. For those of you who are here in person, make sure that you sign up for CLE credit if that's why you're here or if that's important to you, and we submit it to the CLE bar ourselves, and so it's managed for you. For those of you online, what we do is we'll get a spreadsheet of those of you that attended via Zoom, and then we submit that to the bar as well. So you don't have to worry. For those of you possibly watching this when later on, we will stream this on our website. There's a form that you will fill out and a code that you submit when you do that. But for those of you here today watching this live, your CLE stuff will be managed. So if you are on Zoom, please make sure you are muted. We don't want to have, we're excited to hear our speakers. We're not excited to hear your dog or children or whatever. So with that, I am very happy to turn it over to today's presenters, Shane Cashin and Wednesday Selassie. Thank you all so much for being here.
Good afternoon, everyone. I'm just going to give a brief introduction or introduce myself, and Shane will introduce himself, and then we're going to be co-presenting the slides, so we'll be popping up and down during the meeting. So as I said, my name is Wednesday Selassie, and I'm a housing attorney at Montana Legal Services. Before joining MLSA, I practiced for 18 years in Ohio, both in private practice and at the Ohio Attorney General's office. I'm a 2000 graduate of the University of Toledo College of Law. This fall will mark my second anniversary at MLSA. We are a statewide legal services law firm representing clients, low-income clients in many areas, including housing. I'm one of three full-time housing attorneys for statewide housing issues. 60% of our cases involve evictions. We also advise and represent on other issues, including security deposits, repairs, other types of housing issues too. We provide advice, limited and full representation to clients across the state. We have 3 offices, one here in Helena, one in Billings, and in Missoula, where I work out of. I'm excited to join you today to talk to you both about the changes in the Landlord Tenant Act and also the MEET program.
Hello, my name is Shane Cashin. I am the reference librarian at the State Law Library of Montana. Additionally, I am a contract MEET attorney where I handle advice calls for Montanans facing eviction issues. I am a 2020 graduate of the Alexander Blewett III School of Law, and I have been working at this state law library and for the MAAP program for about 1.5 years now. I am excited to present this information to you and to give you an update on landlord-tenant law in Montana.
So Shane and I are going to cover a number of House bills that recently passed and became law. So we'll have a legislative update. We'll also be talking about common issues in landlord and tenant law and do an overview of the Montana Eviction Intervention Program. And we have a speaker from MLSA who will speak on the pro bono legal services as well as the MEET program and how to get involved. So in terms of the legislative update, the first bill that I will speak on is House Bill 282. And it provided for some general revisions to the Residential Landlord and Tenant Act. So there were some remedies that were provided in House Bill 282 for landlords when there's been a refusal of access by the tenant. And so before 282 was passed, if a tenant refused to allow lawful access, that is, they removed or replaced locks or added a new lock, the landlord could either obtain injunctive relief to compel the access or terminate the rental agreement. Since the passage of House Bill 282, if a tenant refuses access, removes, replaces, adds the locks, the landlord can now obtain immediate injunctive relief to compel access. They may also issue a 24-hour notice to correct. If the tenant does not correct what's being complained of and remove, the lock, the landlord can provide a 24-hour notice to correct and issue a 3-day notice to terminate the rental agreement if there is no correction.
Here we go.
Yes.
House Bill 282 also changed the timelines for eviction, both with a written answer, the hearing, and an appeal. So I'm going to go through the before and after again. So before 282, once a tenant was served with an action for possession, the complaint to evict, the tenant would need to file an answer within 10 business days. After 282, the tenant now has 5 business days from the date of service to file an action. The timeline for hearing has also changed since 282 was enacted. Before 282, the court had 14 business days to set a hearing once the tenant filed an answer. But now, since the change in law, there must be a hearing within 10 days after the tenant files an answer. The one exception to this is if there's a lawsuit filed under Montana Code Annotated 7024-321, which we'll get to in just a moment. And in that case, the court must set the hearing in 5 business days. So in terms of the appeal, if a case is before the justice court, and we know justice and district courts have concurrent jurisdiction to hear housing cases, and oftentimes it's the jurisdictional amount which decides whether the case is to be brought before justice or district court. Most justice courts have a cap of $15,000. So if the amount that the landlord is claiming is owed for rent and damages is under $15,000, they can file in justice court. Many justice courts are courts of record. And so regardless, they can be appealed. The decisions can be appealed to district court. Some cases are filed in district court to begin with, again, because the jurisdictional amount is above the $15,000. I would check with your local rules on the jurisdictional amount. That's a general statement that I made as far as the $15,000. It can vary, but so back to House Bill 282. So before the statute was passed, the district court had 14 days within which to schedule a hearing on the appeal once the case had been transmitted from justice to district court. Since the passage of 282, the hearing for the appeal must be held within 10 days after the case has been transmitted. Again, there's a carve out for any violations alleged under MCA 7024-322. And in those cases, that appeal has to be heard within 5 days. So MCA 7024-321, what is that? I'm not going to read through the entire statute, but basically this codifies all of the responsibilities that a tenant has to maintain a dwelling. So if there is a tenant that the landlord is alleging violates this section, we can pick out a couple here. For example, if they're not keeping the unit reasonably clean and safe as a condition of the premises, that could be one. If they're not getting rid of garbage, rubbish, that could be another. Using the premises appropriately under under G, damaging, destroying. Again, if allegations of violation of this section are being complained of, the 5-day for hearing and appeal would apply. Okay. So for the damages hearing, just to kind of back up a little bit, complaints are filed and they may allege rent is owed, late fees, they want possession of the rental, there may be damages to the rental. The landlord may not know unless they've done a walkthrough or inspection. And so oftentimes, the complaint will include all of these things. Under 282, a landlord had a claim for possession and rent and a separate claim for actual damages for any breach of the rental agreement. Since passage of 282, the landlord may bring a claim for possession, rent, and actual damages in the same action. Oftentimes judges will bifurcate, and what they'll do is first have a hearing on rent owed and possession. And then once, if it's determined that the landlord should regain possession, the landlord goes back in, assesses the damages, and then there would be a subsequent hearing on damages once the landlord knows what the damages are. After 282, it required that the damages hearing for a breach of the rental agreement must be within 45 days after the claim for possession and rent has been adjudicated. That was not previously articulated, but is now under 282. Holdover damages, that's another remedy that House Bill 282 brought about, or I should say, better articulated. I'm not sure. Let me explain what holdover damages are first. So in order for a landlord to evict a tenant, they must first terminate the lease. That is step one. They must do so in writing. A writing, as we know under Montana law, can be an email, a text, or a letter posted or mailed to the tenant. The termination letter must state whether it's for cause or without cause. And if it is for cause, give the appropriate number of days for termination. For example, non-payment of rent under Montana law is a 3-day pay or quit. So you have the opportunity to cure and pay the rent within the 3 days. If you don't, the lease would terminate after the 3rd day. So the termination letter needs to state the purpose, the correct number of days, and the landlord has to wait those number of days before going and filing a complaint. If the tenant stays beyond the termination day, they may be considered a holdover. That's where holdover damages comes to play. And so before House Bill 282, the court had to find that the tenant's holdover was purposeful and not being done in good faith. Okay, so there had to be evidence of that. Since 282 is enacted, however, there is a presumption under certain circumstances that the holdover is purposeful. And so it creates a presumption that if the landlord terminates a month-to-month tenancy without cause and the tenant remains in the unit after the termination date, the holdover is purposeful, because with a no cause termination, there are fewer defenses available. And so there's a presumption that it is purposeful. So it's easier to prove holdover damages under that scenario. There were also some changes to the language regarding distinguishing between month-to-month tenancy and more than a month-to-month tenancy. It could be a 6-month or a 1 year. And so you may want to look at the statute as well to see how that was discussed. Shane?
The next bill we want to discuss is House Bill 283, which prohibits local governments with self-government powers from deviating from the Residential Landlord and Tenant Act or the Montana Residential Mobile Home Lot Rental Act. So previously, a local government could create ordinances that would affect a landlord-tenant relationship as long as that ordinance did not interfere with the Residential Landlord and Tenant Act. The statute 7-1-111 outlines the powers that the prohibitions on the powers a local government may exercise. Subsection 13 was the subsection that concerned landlord and tenant situations. Changes to this statute include the addition of Chapter 33 to the list of chapters within Title 70 that local government cannot interfere with activities. The legislative change also eliminated the sentence, "This subsection is not intended to restrict a local government's ability to require landlords to comply with ordinances or provisions that are applicable to all other businesses or residences within the local government's jurisdiction." Essentially, landlords have been exempted from other ordinances that would affect businesses under this House bill. Additionally, at this point, a local government with self-sustaining powers cannot create any ordinance that would affect a landlord's ability to interact with their tenants. One example of this is anti-discrimination ordinances that have been passed in cities like Bozeman or Missoula that strengthen the discriminations that can be alleged against a landlord, such as for sexual orientation and LGBT people. Such a ordinance would not be applicable now under House Bill 283. And ultimately, the House Bill 283 sought to create an exclusive regulatory standard throughout the state regarding landlord and tenant law, and requires that only chapters 24, 25, and 33 be followed in relation to landlord tenant situations.
With regards to House Bill 488, it made some revisions to the Residential Tenant Security Deposits Act. And so one minor change is now public housing authorities are required to follow the language of the statute. A more major change is, and I'm going to get to it in a second, but generally speaking, cleaning charges cannot be charged against the tenant for normal maintenance performed on a cyclical basis. So before the change, a landlord would have to give the tenant within 30 days of the tenant vacating the premises a list of deductions that they planned on taking from the security deposit. And the tenant would have an opportunity to dispute those deductions. If the landlord did not provide a list of deductions within 30 days under Montana law, they are not supposed to deduct any monies from the security deposit. So this bill, how it changed it is unless, and it's underlined here, unless the residential agreement is already terminated pursuant to 7024-427, which we just went over, or 7033-427, which is the Mobile Home Lot Rental Act, similar provision, and the landlord has a pending claim for actual damages filed in suit. Under those circumstances, the landlord is not required to give the 30 days list of deductions to the tenant, presumably because there will be a damages hearing. As we discussed, the court bifurcates. There will be a damages hearing on the damages, and the security deposit should be addressed as part of that damages hearing. So that is regarding cleaning charges cannot be charged. I may have flipped these a little bit, my apologies. So the cleaning charges, that relates to if there's additional cleaning that the landlord feels needs to be made, they have to give written notice to the tenant and allow the tenant to go back in 24 hours to go back in and make that additional cleaning. So again, if there's this pending lawsuit with a pending claim for actual damages, the tenant's not given that notice and 24 hours opportunity to go back and clean, nor are they given the list of damages within the 30 days under those scenarios. So here's an action for possession statute. The first one, again, 7024-427 is the Landlord Tenant Act, and 33-427 is the Mobile Home Lot Rental Act. And again, under those two statutes, if there's pending litigation and a pending damages hearing, there's no requirement for the landlord to give the 30 days notice, list of deductions, nor allow the tenant an opportunity to go back in and do cleaning within 24 hours.
House Bill 523 is a fairly short bill that creates the requirement that any landlord or business that has received Montana Emergency Rental Assistance funds be put into a database that outlines how much money they have received from those programs. So from the bill, each quarter, the Department of Commerce shall provide a list of recipients that have received funds from the Emergency Rental Assistance Program. The list must identify the amount of funds each recipient has received, and the list must also identify any recipient the Department of Commerce has taken legal action against to collect ineligible or overpayment of the Emergency Rental Assistance funds. This bill will mostly be effective for attorneys who want to prove that a tenant has made payments to the landlord using this act. The way that these funds are dispersed is that the tenant and the landlord fill out an application, and then upon its approval, Montana Housing would generally send an approval letter to both the tenant and landlord outlining what has been received. But this will also allow an attorney maybe working for that tenant to go and outline how much money their client's landlord has received and help show just what the steps the tenant has taken, even through the inability to pay, to get payment to the landlord. Now, the final bill we're going to be covering is House Bill 703, which generally revises the laws relating to emotional support animals. So previously in Montana, landlords were required to accept tenants who had emotional support animals and make reasonable accommodations for those tenants. However, the regulatory scheme was fairly confusing for both tenants and landlords. It involved federal law, specifically 42 USC 3604, which states that property owners and landlords may not discriminate against tenants with disabilities. For the purposes of 3604, discrimination includes a refusal to make reasonable accommodation in rules, policies, practices, or services when such accommodations may be necessary to afford such personal equal opportunity to use and enjoy a dwelling. Now, this doesn't just include physical disabilities, it can include mental disabilities such as PTSD, anxiety, depression, things of that nature. Under the Federal Fair Housing Act, a tenant could request a reasonable accommodation for their emotional support animal by sending an ESA emotional support animal letter to their landlord. The ESA letter did not have to outline exactly what sort of disability the tenant had, or that anything beyond the fact that the tenant has a disability and that the emotional support animals services would be of benefit to the tenant. Now, Montana has since codified the process under the Fair Housing Act for the emotional support animals with some slight tweaks. First, a tenant with a disability or a disability-related need may request and may be approved by a landlord to keep an emotional support animal. However, the landlord does have some leeway in whether or not they will accept that animal. Specifically, a landlord may deny a reasonable accommodation request for an emotional support animal if that animal poses a direct threat to the safety or health of others, or poses a direct threat of physical damage to the property that cannot be reduced or eliminated by another reasonable accommodation. that is going to be the primary way a landlord can deny. What exactly a direct threat to the safety and health of others is yet to be seen. Legislative discussion while the bill was being passed did indicate that something as minimal as, say, pet allergies to a landlord with severe allergies could be a direct threat to safety. And so it is yet to be seen just how far that may go. Another thing is that if a tenant's disability is not readily apparent, the landlord can ask for supporting information that will mirror the ESA under the Fair Housing Act. That is further outlined under subsection 2I and 2I2 that essentially directs the reader to the Fair Housing Act, and then also Title 49 of the Montana Code involving discrimination. If a tenant does request to keep more than one emotional support animal, they need to provide supporting information to for each animal that cannot include everything under the same ESA letter. Subsection 4 just outlines that a landlord may not request information under the section that discloses diagnosis or severity of disability, protecting any sort of HIPAA considerations on the part of the tenant. Emotional sub 5 outlines that an emotional support animal registration is not sufficient to identifying whether or not the tenant has a disability related need. It's still, the tenant is going to need that ESA letter. Sub 6 is analogous to the Fair Housing Act as well, in that even though a landlord has to make this reasonable accommodation, a landlord is not responsible for the damages caused by this reasonable accommodation, and a tenant will be responsible for any damages caused by their emotional support animal. Sub 7 has to deal with healthcare practitioners and that they may be subject to disciplinary action for any violation of this section or false reporting. Sub 8, this specifically deals with emotional support animals, not with, say, a service animal, say for a blind person or something like that. And then nothing in the section can be construed to restrict existing federal law. The final bit of this bill is the definitions, and these definitions do outline where there is a major difference between the Fair Housing Act and the Montana codification of it. In Montana, it is required that the healthcare practitioner meets the definitions under 5321-102, which requires that either a physician, professional counselor, psychologist, social worker all be licensed under Title 37 of the Montana Code, essentially meaning that you have to get a Montana doctor to write the ESA letter for the tenant. It can't be, say, a online doctor from across the country that the tenant may have formed a relationship with over the internet. There needs to be a physical relationship with a Montana doctor for this to apply. Okay, and with that, we are at the end of our legislative update. This will be the time to take questions. First, do we have any questions here in person? Oh, yes.
First one for Wednesday. You talked earlier about the jurisdictional conflict, jurisdiction between justice and district court, but then you overlaid that with the $15,000 monetary jurisdiction limit in justice court. Has the Supreme Court or the legislature acted on that? Because I know there are some justices of the peace who believe that that monetary jurisdiction limit does not limit their jurisdiction because they have concurrent jurisdiction.
So I'm not aware of the Supreme Court
Can
weighing.
you summarize the question again, just so the people online? Can hear it?
Sure, I can certainly try to, or you could always come up as well if I don't correctly summarize. But so in my discussion, I talked about there being concurrent jurisdiction for judges both in justice court and district court to hear these housing cases. However, justice courts have jurisdictional caps like small claims is 7,000, I believe. Justice court is around 15, and anything above 15 needs to be heard in district court. And so there will be situations the landlord will file in justice court, believing that the amounts are under 15,000. However, the tenant may then also answer and assert their own counterclaims, at which point it might be above 15,000. Who knows what they're, so there's that. And then, so the justice court will generally look at that and see, you know, I can't order relief, a judgment in excess of 15,000. So you need to either refile, or I'm going to have this removed to district court for the case to be heard. And so your question is, there are some justices of the peace that believe that they can hear cases above 15,000 because they have this concurrent jurisdiction. And I'm not aware of the courts, the Supreme Court ruling on that issue. I only have the information that I have, which is there is concurrent jurisdiction. So both courts could hear a housing eviction case. However, because of the jurisdictional amounts, that limits justice court in terms of relief that a judgment that they could issue, that they may, you know, they could hear the case, but they can't issue a judgment in excess of 15,000. So they may not want to hear the case, and they may want it to go to district court if there's any question about, you know, the relief that one or both parties are seeking. Is that satisfactory?
Well, yeah, the Supreme Court, you're not aware of the Supreme
I'm
Court,
not.
because I know that there are some out there, just the peace,
Mhm.
who will hear a case if it's been filed in a landlord tenant case that has damages in the prayer of over $15,000 because of that concurrent jurisdiction statute overriding the monetary cap.
Interesting. So the questioner was saying that he is aware that there are justice of the peaces that will hear the case and presumably order a judge, maybe provide a judgment in excess of 15,000, even though that's their jurisdictional cap, because they do have concurrent jurisdiction. So that's something to look into. Yeah. Thank you. Any other questions?
All right, we're ready to look at chat now. Okay, Amy Hall wants to comment that she wants to correct one statement. A jurisdiction of justice court does not vary, it is always 15,000. The question from, I hope I'm saying this right, Mies Fairber. When do new laws go into effect? House Bill 282 is in effect now. I believe most of these bills went into effect upon signing. Wednesday, do you know? Yeah, HB 282 definitely is in effect now. I would have to double check on 283, 48, 523 or 703. Okay, Brandy Caristia wants to ask, do tenants being evicted for reasons such as non-payment of rent still have the right to receive notice of additional cleaning and damages that are withheld from the security deposit? No, if they're being evicted for non-payment of rent, then the action for possession statute 427 would trigger, and they would not need to give notice of additional cleaning. Mize wants to ask if we can get a handout of materials. I can send a copy of the slides to everyone who registered after the event, and I'll make a note to do that. Tenant can demand jury trial, is that correct? Yes, that is correct. Roberta Bergeson wants to ask, how do I access the recording? We will be posting this recording on courts.mt.gov under our CLE section. Amy Hall wanted to outline the case Alto Jake Holdings LLC v. Donham 2017 MT 297 holds that the Justice Court cannot enter a money judgment in excess of the jurisdictional amount. In 2017, it was 12,000, and that was the amount in controversy at that case. Now it's 15,000. Tammy Lund Smith. Oh no, has to do with CLE credit. We'll deal with that afterward. Brandy asks, a client received a summons listing 10 days to answer after this law went into effect. I called to ask if 5 days or 10 days applied, and the clerk of Yellowstone Justice Court told me the date on the summons applied. Any thoughts? I would say that if the summons says 10 days, it is incorrect, but that the tenant would have an argument to, or would be able to make the argument that they did see that date on the summons. I mean, generally the summons needs to be provided by the landlord, and if the landlord is sending in summons with an incorrect date, then the error is on the part of the landlord, but it would ultimately be up to the judge to decide. And Travis asks, what new laws do you think the legislature will enact next legislative session? I'm not sure, Travis. Sorry. Okay. We don't have any other, one more question.
One last one, is the presumption that a holdover is purposeful also applicable to the mobile home?
Yes, it is. Okay, now that we're done with the legislative update, I would like to talk about common issues in landlord tenant law, just things to look out for if you're practicing in this area. I do work for the Montana Eviction Intervention Project, and so my perspective will be from the tenant side more so than the landlord side, but these rules apply to both parties. Okay, so the first thing that I look for in any sort of termination situation is notice, and whether or not notice requirements have been followed properly. And I'm not going to read this entire statute out. This is just here for reference. But effectively, in most cases where notice is given, it has to be done in a correct or vacate method, in that if the tenant does not correct the issue within the stated time, they must either, or they must leave, but they do have the option to fix the issue. The most common one that you would see would be for the non-payment of rent. Rent is due at the beginning of the month if there's no lease agreement, or at the time that the lease agreement states. And if the tenant fails to make that payment by that time, the landlord may issue a 3-day pay or vacate notice. So if the landlord is not paid within those 3 days, the landlord then has the option to terminate the lease agreement. Other 3-day periods include when there's an unauthorized pet at the residence, or any unauthorized tenants living at the residence. If the landlord gets any information relating to that, they may also issue a 3-day pay or vacate notice, which, if not corrected, would allow the landlord to terminate. The next major one I think you would see has to do with sub D, which is when the non-compliance is not due to non-payment of rent, unauthorized pet, unauthorized person, or situations involving verbal abuse against the landlord by a tenant. These would be like noise complaints, maybe clutter in the yard, minor complaints or minor violations of the lease agreement that don't rise to the same level as other violations. And in that case, the tenant will have 14 days to correct or vacate. So another thing to take into account is that this pay or vacate, this correct or vacate standard only applies on the first violation within a 6-month period. If a tenant violates the lease agreement in the same act, or like a same or similar type of action, the landlord can simply terminate the lease agreement with 5 days notice upon that second violation. Other than that, subsection F outlines when there's verbal abuse by the landlord or tenant. It allows the landlord to terminate without any sort of this gets to be complicated because it says that they can terminate with a 3 days notice, but the tenant can if the tenant can adequately remedy the non-compliance, the agreement doesn't terminate. But how you can say correct a verbal abuse situation can vary based on the parties and how the abuse affected the landlord. And so that gets to be a fairly tricky situation. Beyond that, a landlord does not have to give any sort of option to correct if the tenant destroys, defaces, damages, impairs, or removes any part of the premises or creates a reasonable potential that that may happen. Beyond termination for cause, Montana law does allow for no cause terminations in the event that the tenancy is week to week or month to month. In that case, either the landlord or tenant may simply give a 7 or 30-day notice of termination to the other party, and then the lease agreement will terminate upon that date. Now, another issue I see fairly often is retaliation by a landlord. Essentially, a landlord may not retaliate by increasing rent, decreasing services, or by bringing or threatening to bring an action for possession in 3 situations. The first is when a tenant has complained of a violation applicable to the premises materially affecting health and safety to a government agency charged with responsibility for enforcement of a building or housing code. The second instance is when the tenant has complained to a landlord in writing of a violation under 7024-303, which is the landlord's responsibility to maintain the premises in a health and safety manner for the tenant. The third is when a tenant has organized or has become a member of a tenants union or similar organization. Most often you'll see subsection B in these situations is when a tenant has complained about a violation in writing, such as no power or a broken stove or something large that needs to be taken care of. And the law is going to presume that if the tenant has made this complaint and then the landlord has terminated tenancy within a 6-month period after, that the landlord is simply terminating tenancy rather than dealing with the health or safety issue that the tenant has raised. Now, this isn't going to be an absolute bar against, say, the termination of a month-to-month tenancy. However, this is one of the only ways you can push back against the termination of a month-to-month tenancy. And so another thing to take into account here is that it does not apply if the tenant is defaulting rent. So if a tenant has stopped paying rent and then decided to complain about some issues affecting health and safety before the landlord could issue any sort of pay or vacate or termination notice, it's not going to be a way for the tenant to slip that in and evade the default and rent issue. Unlawful ouster exclusion or diminution of service is fairly similar to the previous retaliation statute. Ultimately, this statute is stating that a landlord cannot take any sort of self-help measures when dealing with a tenant. A landlord, say, if a landlord hasn't received rent, they cannot simply come in and say change the locks when a tenant is at work. They can't turn off the hot water, electricity, gas, essential service, anything like that. A landlord is required to go through the law in these situations. If a landlord does try to unlawfully ouster a tenant, the tenant may, depending on the situation, recover tenancy or in possession of the property, or recover an amount no more than 3 months periodic rent or treble damages, whichever is greater. So finally, one issue to look out for is a failure of landlord to maintain the rental premises. Essentially, whoever's speaking, could you please mute your mic? So it looks like we still have sound. All right. So if there is a failure for the landlord or the landlord to maintain the premises, if there's some obvious health or safety issues or some even smaller issues with appliances, the tenant has a couple of options. First, the tenant needs to deliver written notice to the landlord outlining that there has been an issue with the health or safety or problem with the household. And the tenant will, it gets to be a little confusing. They have to state that if the breach on the landlord's part is not remedied within 14 days, that the lease will terminate within 30 days from the notice. So effectively, landlord only has 2 weeks to correct the issue, but the tenant is also giving a 1 month notice of the termination of tenancy at the same time. So once the tenant has delivered that notice, there's a couple things that they can do. First, if the breach is remediable by repairs and the payment of damages or otherwise, and the landlord adequately, or I'm sorry, I'm reading the wrong part. If the breach costs more than 1 month's worth of rent, the tenant may terminate. If, however, the breach does not cost more than 1 month's rent, say rent is $900 a month and there's a broken stove for $700, the tenant can tell the landlord this and state that if the landlord does not say fix the stove within a reasonable amount of time, that the tenant will just hire someone to come fix it and deduct the cost from rent. But again, that can only be, the repair and deduct can only be used if the repairs do not cost more than 1 month's worth of rent. All right, and with that, we are done with our common issues in Montana landlord and tenant law. And I would like to turn this over to Ellie, and Ellie is the pro bono coordinator for Montana Legal Services, and she would like to speak briefly about the Montana Eviction Intervention Project.
Hi, everybody. Thanks, Shane. Thanks, Wednesday. So I'm the pro bono coordinator for legal services. I am not an attorney. It is my job to encourage all of you licensed attorneys to please try and fulfill your recommended 50 hours a year. So Shane is one of our wonderful MEEP contract attorneys. We launched and I'm saying MEEP, that's the Montana Eviction Intervention Project. It's just too long to say. So we launched the MEEP program in October of 2021. We are still extremely busy and we are seeing a lot of these cases come in. In short, MEEP contract attorneys receive $75 an hour and they can take cases on for full representation, limited scope opportunities, or to be on our regular phone advice schedule. MEEP provides tenants facing court-ordered eviction with free legal representation with the goal of helping tenants secure rental assistance. As we all know, there is no right to an attorney in a civil case. With evictions being the leading cause of homelessness, it is imperative to have MEEP contract attorneys to step in and inform our clients of their legal rights or how to enforce them. This is so important because once a tenant has an eviction filing on their record, many landlords will refuse to rent to them again, regardless of whether a judgment was filed. 182,000 is the number of Montanans who are eligible for legal aid. There is one legal aid attorney for every 12,133 low-income Montanans who may need one. So rural Montana, a huge focus of my project is expanding attorney services in rural Montana. In some of those smaller towns, there may be conflicts of interest, 1, 2 attorneys living there, maybe none at all. So if you're interested, please consider joining our pro bono phone advice project, which means you can call from anywhere in your office, provide an hour of legal assistance, limited scope legal assistance to low-income Montanans all across the state. So that's 1 hour of your time. We send you a conflict check, we send the case file, and then you call the clients and advise them. Right now, I really need family law volunteers. So I'm gonna put a sign-up sheet over there in my business cards. I hope you'll consider donating your time. At the end of June 28th, we have another CLE that will be Zoom only, and we're going to be discussing legislative updates that affect poverty law issues. So we'll do another recap of these housing bills, but we'll also go further in depth to employment, housing, consumer issues, etc. And in the fall, I'm launching a Helena Clinic, which will be in person. So please consider volunteering. That will be with Trish Klinke and Aaron Linz. And we're going to have about 12 slots from 5 to 7 in the evening to come in and sit down with our clients and provide an in-person 1 hour legal advice appointment. Thanks, everybody.
Thank you, Ellie, very much. All right, so we are now going to look at chat. All right. And so Evie Hudson asks, are you aware of any legislative changes that relate to squatters, e.g. holdover after termination contract for deed? I'm only aware of the changes that pertain to the Residential Landlord and Tenant Act and the Mobile Lot Rental Act that creates the automatic presumption for holdover tenancy if a tenant stays, say, past a term lease for cause, or even if a tenant stays past a month-to-month no-cause termination. So Greg Murphy asks, with the new short hearing deadlines, the busier justice courts are going to face some serious challenges, particularly if the tenants demand jury trial. I agree. I think that the 5-day answer time is going to create a lot of issues on the tenant side specifically. I think beyond just a tenant, the tenants demanding jury trial and plugging up the system that way, there's also going to be issues with tenants not even answering on time given the short time frame for answering. Can students volunteer? The only people who can volunteer for the MEET program that I'm aware of are licensed members of the Montana Bar.
That's correct. But if you are a student at the University of Montana, we do have a housing justice internship that is supervised by Klaus City. Again, I'm going to put my email in the chat so you can reach out to me if you're interested. In addition to the housing justice internship, we do offer a family law clinic at the law school as well once a month, and you'll be able to be mentored by a Missoula County attorney and meet with a client face-to-face.
Okay, I'm gonna give one last chance for anyone to ask any questions in the chat. And does anyone else here in person have any questions? All right, well, thank you very much, everyone. I appreciate your time and spending your lunch hour with me to go over Montana landlord and tenant law. And I hope you have a great rest of your day.